Welcome, everyone. UN Global Requirements for Personnel Records session presented by Bill Safady. This session is sponsored today by GovQA, and GovQA provides SaaS-based collaboration tools enabling the nation's top cities, counties, and state agencies to process complex work while facilitating internal and external communications in a highly secure environment. With remarkable growth and impressive client base, GovQA continues to drive innovation and deliver world-class solutions to government entities of all sizes. We thank GovQA for sponsoring this session, and please visit them virtually in the sponsors section of the conference to learn more. And now it's my honor to introduce to you our speaker for this session, Bill Safady, who is a records management consultant, researcher, and author based in New York City. His latest books are Managing Information Risks, published in 2020, and the fourth edition of Records and Information Management, Fundamentals of Professional Practice, which will be published in the spring of this year. He is currently completing a research report on global requirements for personnel records, which will be published by the ARMA International Educational Foundation in 2021. As a consultant, Dr. Safady provides a variety of analytical services, including developing strategic plans and governance models for records management programs and preparing cost calculations and justifications for specific records management projects, to name a few. So I would like to welcome all of you to this presentation, and I will hand it over to Bill now for this wonderful session.
Thank you, Anna. And let me pull my slides up if I can and get started with this. All right, so I'll just say a few words. First of all, thanks to the sponsor for this, and thanks to everyone for attending. So when I first started in records management work in the 70s, I wondered why there weren't reference sources that you could look at to find out how long records needed to be kept, why somebody hadn't done that. Well, now that I've done it, I know why somebody hadn't done it. So I'll explain more about this as we go along. So let's get started. This presentation summarizes findings from a study that was prepared for the ARMA International Educational Foundation, the AIEF, a not-for-profit organization that supports research on topics related to records and information management. So the report on which this presentation is based will be issued in the first half of 2021 by the AIEF. I'm just finishing the report now, and then it's got to go through copy editing, and that'll probably have some editorial changes that need to be made. All AIEF sponsored reports are available free of charge at the organization's website, which is www.armaedfoundation.org. This report is intended as a companion piece to a report on global retention requirements for accounting records, which I wrote for the AIEF in 2019. That report's also available at their website. Compared to the report on accounting records, this report has a broader scope. It covers record-keeping requirements beyond retention, and compared to the accounting report, it required much more extensive research and much greater time and effort to identify relevant laws and regulations, the order of magnitude more difficult than the accounting report. The report identifies and summarizes legal and regulatory requirements for content, storage, retention, and use of personnel records. This is a category of recorded information, like accounting information, that is created and maintained by virtually all businesses, government agencies, and not-for-profit organizations. There aren't too many categories of records that are encountered in almost every type of organization. Accounting is one of them, personnel records another, and then occupational safety and health records third. The AIEF report is intentionally limited to legal and regulatory requirements for creation, storage, retention, and use of personnel records, and intentionally omits operational considerations, which can have a significant impact on record keeping, but are out of scope for the report that I did. The report doesn't attempt to provide record-keeping advice, simply identifies requirements without comment or interpretation, and that's what we're going to do in this presentation today. The AIEF report is intended for records managers, information governance specialists, human resource professionals, compliance officers, attorneys, risk managers, and others who need to understand legal and regulatory requirements for personnel records in specific countries where such records are created or maintained. In particular, the report is intended for organizations that need to know about legal and regulatory requirements in multiple countries where they maintain records about employees. Those organizations are of two types: multinational organizations, which have a headquarters in one country, but branches or subsidiaries in other countries and have employees in all of those locations, or transnational organizations, which have autonomous operations in multiple countries, each operation having employees in that country. Organizations that have employees in multiple countries include corporations, partnerships, universities, scientific and medical research organizations, foundations, scholarly and professional associations, cultural institutions, philanthropic organizations, charities, and religious groups. Any of these groups might find the information that's contained in the AIEF report in this presentation to be useful in helping them establish record-keeping policies and procedures. For purposes of the AIEF study and this presentation, personnel records are broadly defined to include any records that employers maintain about individual employees. A given personnel record may contain information about one employee or multiple employees, but the employees must be individually identified. Management reports or other records that consist of statistical compilations of information about employees in aggregate are out of scope. Personnel records may contain personal or job-related information. In most cases, they contain a combination of both types of information. Personnel records are often characterized as personnel files because they are stored in paper or electronic folders, but personnel records also include databases, registers, notebooks, and related documents that contain information about employees and that are covered by labor laws and regulations. That's the scope for this particular study. The records must be covered by labor or employment laws and regulations. The AIEF study intentionally omitted employee information that may be included in pension records, which are covered by social services legislation rather than labor laws, and workplace injury or illness records, which are covered by occupational safety and health regulations. The study is further limited to legal and regulatory requirements for personnel records maintained by employers about their own employees. Employee information maintained by government agencies, employment agencies, labor unions, or other groups is out of scope, even though those types of records might be covered by labor laws and regulations. This is a global study. It surveys retention requirements in every country in the world for which information is available online, which is every country except one, North Korea. Other kinds of information are available for North Korea, but not labor laws and regulations. For the accounting study, there were 3 or 4 other countries for which information was unavailable online in 2019, but those countries have caught up and labor laws and regulations are available for them now. So in defining a country, this report follows the Montevideo Convention on the Rights and Duties of States, which defines a country as a sovereign entity with defined territorial boundaries, a permanent population, an established government, and the capacity to enter into relations with other sovereign entities. Depending on the source, the number of countries in the world ranges from less than 195 to more than 200. At one extreme, the ISO 3166 standard lists 249 countries, but many of the listed entities are dependent territories and special areas of geographic interest rather than sovereign states. At the low end of the range, the United Nations has 193 member countries. take away North Korea, for which information was not available, and add Taiwan and Kosovo, which are not UN members, but are recognized as sovereign entities by some UN members. And the total for purposes of this report is 194 countries. The Holy See, which is a UN non-member observer state that meets the criteria defined in the Montevideo Convention, is omitted because Vatican City has a non-commercial economy. It does have a labor law, but it does not signify record-keeping requirements. Palestine, which is also a UN non-member observer state, is omitted because its territorial boundaries have not been formally established. So in addition to the sovereign states, the report covers record-keeping laws and regulations in 8 dependent territories: Bermuda, the Cayman Islands, Gibraltar, Guernsey, Hong Kong, the Isle of Man, Jersey, and Macau. These dependent territories were selected because various multinational and transnational organizations operate within their borders. Because these dependent territories have a degree of autonomy, their record-keeping laws and regulations may differ from those of the sovereign states that control them. So adding the sovereign states and the dependent territories, the report covers laws and regulations in 202 political jurisdictions. A little background information is necessary to understand legal record-keeping requirements in the countries that are covered by the study. Categorized by their governmental structures, countries are divided into 2 broad groups: unitary states and federated states. Most countries and all dependent territories are unitary states. They have a centralized government that issues laws, regulations, ordinances, and other legal instruments that apply to the entire country or territory. The authority of subnational jurisdictions like a county or a municipality, where they exist, is limited to administrative matters that don't generally impact record keeping. In federated countries, the national government shares power with subnational jurisdictions, which may pass laws that specify record-keeping requirements for matters that come within their authority. That's the situation in the United States, Canada, and Australia, for example. Of the 194 sovereign nations covered by this report, 26 are federated countries. All of the unitary states covered by this report have national laws and regulations that specify requirements for personnel records. Most federated countries have national laws that specify requirements for personnel records, but subnational jurisdictions, like states or provinces, may pass their own laws or regulations with additional record-keeping requirements. Those subnational requirements are outside the scope of this study, but they can have an impact on record-keeping practices. In the United States, for example, most state laws and regulations mirror federal requirements, but some states mandate longer retention periods for personnel records in specific situations. The inclusion of subnational jurisdictions in this study was just impractical. It would have more than doubled the size of the study and required access to some laws and regulations that are not readily available online. The US, for example, has 50 states plus the District of Columbia, 5 self-governing territories. Canada has 10 provinces, 3 territories. Mexico has 31 states. India has 28 states and 8 union territories. Australia has 6 states, 3 internal territories, 7 external territories, and so on. The next several slides discuss the types of laws and regulations that specify requirements for personnel records. All countries in this report have 1 or more labor laws or regulations that specify the types of records that employers must maintain about their employees. These employment laws and regulations may also specify how long personnel records must be kept and the conditions in which they are to be stored, used, or disclosed. We'll talk more about this as we go along. Most countries have a unified labor code, sometimes termed an employment code or a general labor law, that consolidates all record-keeping requirements in a single instrument, which may be supplemented by rules or regulations that specify how the requirements will be implemented. These labor codes are relatively easy to identify and locate online using straightforward search methods. For English-speaking countries, for example, a Google search for labor code followed by the country name is typically sufficient. Where English is not the official language, labor code should be the words or the phrase labor code should be translated into an appropriate equivalent, code du travail, for example, in French. In other countries, record-keeping requirements are scattered in multiple labor laws, regulations, decrees, ordinances, and other sources, which must be individually located and examined. This is much more difficult than in a country where there's a unified labor code. In Ireland, for example, personnel record-keeping requirements are presented in 18 labor laws and regulations, although that's an extreme case. 6 to 8 relevant laws and regulations is a more likely occurrence. Regardless of number, scattered legal instruments can be difficult to identify. In most cases, you have to consult a secondary source in order to obtain a complete list for a given country. And if a country has 10 labor laws, maybe only 5 of those might be relevant for purposes of record keeping, but you still have to look at all 10. Two-thirds of the countries covered in this report have laws that are variously called an electronic transaction law, electronic commerce law, or electronic document law that address the legal status of electronic records as acceptable substitutes for paper documents for any purpose for which the records might be intended. Those laws apply to personnel records, provided that they are not overridden by record-keeping requirements that are specified in labor laws or other laws. In most cases, electronic record-keeping laws also address the evidentiary value of personnel records that contain electronic signatures. Some countries have separate electronic signature laws that deal specifically with digitally signed documents as substitutes for documents with handwritten signatures, but those laws do not address the legal status of electronic records in general. They have a more limited scope. Most labor laws and regulations specify statutes of limitations, sometimes described as periods of prescription, for initiation of legal proceedings related to breaches of employment contracts, unfair dismissal, unpaid wages, and other violations of employment laws. In some countries, however, the limitation periods for specific infractions may be specified in the country's general civil code rather than in labor laws, so those codes may need to be consulted. As we'll discuss in a later slide, statutes of limitations can have an impact on retention decisions for personnel records in some situations. Two-thirds of the countries covered in this report have data protection or privacy laws that specify requirements and restrictions for collection, retention, and disclosure of information that identifies a given person. It's not the same two-thirds that have electronic transaction laws. There's some overlap, but it's not complete. These data protection and privacy laws apply to personnel records that contain personally identifiable information about an organization's employees. Some labor laws and regulations also incorporate data protection and privacy requirements, but most do not. Data protection and privacy laws are generally modeled on Directive 95/46/EC of the European Parliament, or increasingly on that directive's successor, the General Data Protection Regulation, the GDPR. The GDPR, of course, is a European regulation, but many other countries have modified their data protection and privacy laws to come into line with the GDPR's requirements. For each of the 202 countries and dependent territories, the AIEF report identifies and summarizes requirements for personnel records in the following categories. First, the content of personnel records and the retention of personnel records, which is probably of greatest interest to a records management audience, acceptable formats or storage media for personnel records, specifically whether and to what extent electronic records can satisfy record-keeping requirements. Storage locations for personnel records. Some countries have rules about the locations where personnel records must be kept. Requirements for access to and disclosure of personnel information. And then finally, time limits for dispute resolution where personnel records might be relevant. These are going to be discussed in the next set of slides. Employers in every country are required to maintain personnel records that document an employment relationship with individual workers. All countries have one or more laws or regulations that specify the types of information that must be created, collected, and maintained about individual employees, but those laws are not necessarily complete. They're not a total record-keeping guide. They do not specify all the records that an employer should prudently maintain, only the ones that they are compelled to maintain. The information to be maintained about individual employees can be divided into two broad categories: personal information and job information. Personal information includes the employee's name, address, date of birth, nationality, country of origin, and for countries with a large number of foreign workers, their citizenship. Job information typically includes the job title, description of duties, the required education or qualifications, the working hours, the work location, the leave entitlement, remuneration, meaning the wages and benefits, the starting date, and the termination date, of course, which can't be known at the time the records are initially created. In many organizations, employers are required to provide employees with a written statement of the particulars of employment. This might be included in an employment contract. Where it isn't, a separate written statement is required. In many organizations, records pertaining to individual employees are collected in paper or electronic personnel files, which may be centralized in a human resources department or maintained by individual departments or other business units. While that practice is compatible with operational needs, only 28 countries, less than 15% of the total, have laws or regulations that require or imply that employers maintain a separate file for each employee. That requirement is particularly encountered in Middle Eastern countries and to a lesser extent in certain Eastern European countries. Otherwise, the personnel files just simply not mentioned. More commonly, laws and regulations require employers to keep one or more registers, ledgers, logs, notebooks, databases, or other records that contain information about individual employees. In some countries, personal and job information about individual employees must be contained in a unified register that is sometimes termed the employer's register. This is particularly common in former French colonies. Those colonies tend to have relatively uniform record-keeping requirements and labor legislation. Reflecting the close relationship of personnel and payroll operations, most laws and regulations require employers to keep separate registers of hours worked, including overtime hours and leave taken by individual employees, and the wages that were paid to employees on specified dates. In some cases, the employees who received the wages must sign the register, indicating that they had in fact received them. Separate registers may likewise be required for information about underage employees, including their ages, schooling arrangements, and information about their parents and guardians. The definition of underage employees varies from country to country. In some cases, 16 years old, in some cases, 18 years old. Labor laws in all countries specify requirements for written employment contracts, but fewer than 1/3 of those laws require employers to keep copies of signed contracts, although it's obviously prudent for them to do so. In countries with data protection laws, personal information in employment records must be relevant to and necessary for the purpose for which the information is created or collected. In some countries, labor laws and regulations likewise prohibit excessive collection of information about an employee's personal life, including information about an employee's political or religious affiliations. In some countries, each employee has an employment record book that is collected by the employer on the first day of work and returned to the employee when the employment relationship terminates. Labor laws and regulations may prescribe an employer's responsibility for handling, storing, and updating these books, but they are considered the personal record of an employee's work history rather than a type of personnel record. When employment ends, the employee takes the book with them. It's not a record that the employer is required to keep. This slide provides an overview of retention periods for personnel records in the 202 countries and dependent territories that are covered by this particular presentation. All of these ideas are going to be developed more fully in the subsequent slides. So this is a topic that's of great interest to records managers, and we'd like to have some pretty clear guidance about this from country to country, but in fact, 43% of the countries don't provide any guidance at all. They have laws and regulations that do not even mention the retention requirements for personnel records. The second biggest category provides for retention of personnel records in the 5 to 7 year range, but as we'll discuss in a couple of minutes, the starting point for that retention period is none too clear. Overall, the range is from less than 3 years to 50 plus years. Again, the starting point to be is defined differently from one country to another. There are a few countries that have permanent retention requirements for personnel records, but overall, most have relatively short retention periods. These ideas are going to be developed more fully in the subsequent slides. Labor laws and regulations in 87 of the countries and dependent territories covered by this report do not specify retention requirements for personnel records. As previously noted, that accounts for 43% of the 202 countries and dependent territories covered by this study. The absence of retention guidance suggests that employers can keep personnel records as long as they like, but 49 of the countries without retention requirements have a data protection or privacy law that prohibits the continued retention of personal information that is no longer needed for the purpose for which it was originally created or collected. And some laws give employees the right to request destruction of obsolete and personal information maintained about them. Labor laws and regulations in 10 countries specify a retention period of 50 years or longer for personnel records. 7 of those countries specify permanent retention for all or most personnel records, but 5 of those countries also have a data protection law that prohibits excessive retention of personal information that is no longer needed for the purpose for which it was originally created or collected. Data protection laws do provide exceptions for personal information that warrants permanent preservation for historical or scientific research, but it's not clear whether or to what extent this might apply to personnel records. Some data protection laws require anonymization of personal information that is retained for long-term research. In the remaining countries, which account for more than half of the total, non-permanent retention periods for personnel records range from less than 3 years, actually less than 1 year in several countries, to 10 years. These retention periods presumably correspond to the period of time that personnel records are subject to examination by labor inspectors or other government officials, but it is difficult to generalize because the trigger events vary by record type. Where working hours, wages paid, leave taken, or other information about multiple employees is recorded in a registered log or notebook with a finite number of pages, the retention period begins with the date of last entry, which may be years after the first entry was made. For personnel files, employment contracts, apprenticeship agreements, and other records that pertain to individual employees, the retention period typically begins with the end of the employment relationship. Here are some suggestions for multinational or transnational organizations that want a uniform retention rule that complies with laws and regulations in all countries where it has employees or might have them in the future. Personnel files, employment contracts, and other records that pertain to individual employees might be kept for 10 years after termination of employment, with exceptions made for the 10 countries that require longer retention. Registers, logbooks, or other records that contain information about multiple employees might be kept for 10 years after the final entry. As is customary with uniform rules that encompass multiple jurisdictions, this will result in some over-retention for records maintained in countries that have shorter retention requirements. As a complicating factor, this may violate data protection laws that prohibit retention of personal information that is no longer needed for the purpose for which it was originally collected. If a shorter retention period is desired, 7 years after termination of employment or 7 years after the final entry will comply with legal requirements in 3/4 of all countries and dependent territories, but exceptions will be required for 26 countries that have retention requirements longer than 7 years. Some labor laws and regulations specify the format in which personnel records must be created, stored, and retained. In a bound volume, for example, without blank pages, or in ink without erasures. But most labor laws and regulations don't specify format requirements or restrictions for personnel records, although some are written in a way that implies paper-based record keeping. This is particularly the case with laws and regulations that predate widespread computerization of business operations. Some labor laws and regulations specify that electronic records are acceptable alternatives to paper documents to satisfy certain record-keeping requirements, but those provisions are not typical, and where present, they are limited to a narrowly defined subset of personnel records. In this respect, labor laws and regulations contrast sharply with the national accounting laws, which acknowledge the prevalence of computerized record keeping. But electronic transaction laws establish a legal basis for creation and retention of personnel records in electronic form. As discussed in a preceding slide, 2/3 of the countries and dependent territories covered by this study have laws and regulations that recognize electronic records as legally acceptable alternatives to paper documents for creation, storage, and retention of information that's required to be in written form, but certain conditions must be satisfied. First, the electronic records must be readable throughout the retention periods. Second, the integrity of the records must be maintained. That is, the records must be protected from unauthorized modification. Third, the records must be saved in a form in which they were sent or received, or in a form that accurately represents their original form. And fourth, where relevant, information about the date when the records were sent or received must be preserved. This is in particular relevant for email messages. And then electronic transaction laws also affirm the probative equivalence of paper and electronic records. In other words, paper and electronic records are equally admissible in evidence for legal proceedings. Labor laws and regulations in 27 countries, about 13% of the 202 countries and territories covered by this study, require employers to keep certain personnel records at a worker's place of employment, or if that's not practical, at the employer's headquarters location or another place of business. This is presumably done to ensure that the records are available for examination by labor inspectors during unannounced visits, which is a requirement of most labor laws and regulations. In the absence of a law that mandates workplace storage, personnel records could presumably be stored anywhere, even in a headquarters location in another country or in by a foreign cloud-based storage provider. But in countries with data protection laws, international transfer of employee records that contain personal information is limited to countries with an adequate level of data protection, subject to specified exceptions. This requirement may constrain the implementation of an enterprise-wide human resources information system or other global record-keeping systems that consolidate personnel information in a single repository apart from the country where the employee works. Most labor laws and regulations require employers to make employment records available for examination at any time by labor inspectors or other government officials. Few labor laws and regulations impose other requirements or restrictions on access to or disclosure of employee information. In fact, most labor laws and regulations ignore the subject completely. In a few countries, labor laws and regulations give employees access to a very limited selection of information that employers maintain about them, typically just one register or one set of records. Broader access rights and disclosure restrictions are provided, however, by data protection laws, which give employees access to their personal information and prohibit disclosure for reasons other than the purpose for which the information was originally collected. As explained in an earlier slide, statutes of limitations specify time limits for initiation of legal proceedings, in this case, a violation of employment laws, and those statutes of limitations have some implications for record retention. Labor laws and regulations in 193 of the 202 countries and territories covered by this study include limitation periods for legal proceedings related to unfair dismissal, unpaid wages, unpaid leave, discrimination, or other employment matters. Depending on the country, employment disputes may be adjudicated by a civil court, an industrial tribunal, or a labor mediation or arbitration authority. In some countries, labor laws and regulations require employers and employees to attempt to settle labor disputes amicably before claims can be submitted to a higher authority. Organizations are not obligated to keep records that may be relevant for legal disputes that are not pending or imminent, but it's widely considered prudent to do so, at least to keep personnel records until applicable limitation periods elapse. At a minimum, limitation periods should be considered when making retention decisions for personnel records to ensure that information will be available for resolution of employment disputes. Depending on the country and the alleged violation, limitation periods range from 21 days to 10 years from a specified starting point. The limitation period is 3 years or less in 3/4 of the countries. Short limitation periods have limited impact on retention decisions, but complications arise from variations in the starting point for the limitation period, which depends on the type of violation and varies also from country to country. The limitation period for unfair dismissal usually begins when an employee receives a termination notice from his or her employer. The limitation period for other violations of employment law begins with the cause of action, such as the date that unpaid wages became due. In some countries, however, the limitation period for all legal disputes begins with the termination of the claimant's employment. If an organization wants a uniform retention rule that is compatible with limitation periods for labor disputes in all countries where it has employees or might have them in the future, personnel records for individual employees should be kept for 10 years after termination of employment. This is in keeping with the uniform rule that satisfies legally mandated retention requirements as discussed in the preceding slide. There's another requirement that favors a 10-year retention period. In some countries, employers are obligated to provide former employees with a certificate of employment for a period of time following termination. In Finland, for example, that period is 10 years. Information about former employees must be available to enable employers to fulfill this obligation. For each country and dependent territory, the AIEF report summarizes legal and regulatory record-keeping requirements in the categories discussed in the preceding slides: content, retention, format, storage, access and disclosure, and dispute resolution. In the time remaining, I want to show a couple of examples of country information. This particular example shows the content entry for the United States. As it indicates, employers must maintain both personal and job information about individual employees, the name, address, date of birth, and so on, plus limited information about an employee's work history. This is similar to the kind of content required by laws and regulations in other countries. Retention periods defined by US regulations, as this slide indicates, are relatively short, certainly shorter than some organizations would require for operational purposes. The general retention period for personnel records is 1 year from the date the record was created or the date of the personnel action to which the record pertains. Certain information must be retained for a minimum of 3 years. I want to emphasize that these are federal requirements. State laws may specify longer retention periods for certain purposes. In the United States, federal laws and regulations do not specify format requirements or storage locations for personnel records, but individual states have laws that affirm the legal acceptability of electronic records for most purposes. The United States does not have an omnibus data protection law or other law that specifies access and disclosure requirements or restrictions for personnel records. In this respect, the US is far behind other countries. As this slide indicates, the United States does not have a national statute of limitations for civil litigation related to employment disputes. Legal disputes related to unfair dismissal, unpaid wages, or other employment matters are handled at the state level and are subject to limitation periods specified by state laws. But there are federal limitation periods for legal proceedings related to employment discrimination. 180 days for an EEOC complaint, for example, and 2 or 3 years for discrimination claims under the Equal Pay Act. For comparison purposes, the next group of slides shows the entry for personnel record-keeping requirements in France. I realize I'm going through these entries quickly, but the purpose is to show the kind of information that the AIEF report provides. The full report will be available at no charge from the AIEF website, as I previously noted. As this slide indicates, employers in France must maintain a unified personnel register with prescribed content, as well as a register of hours worked by each employee. Many other countries, including former French colonies, have similar requirements. Compared to the US examples shown in a preceding slide, retention requirements specified in French laws and regulations are more detailed. Of particular interest here, maximum retention periods are specified for certain types of employee information. In most countries, by contrast, record-keeping laws and regulations specify minimum retention periods. The maximum retention periods are in keeping with European data protection requirements that personnel information not be kept longer than necessary for the original purpose for which it was collected. French laws affirm the legal equivalence of paper and electronic personnel records. Storage locations are not specified, but the General Data Protection Regulation, the GDPR, which applies to all EU member states, prohibits cross-border transfer of personal information to countries that lack adequate protection. So there are some limits on where personal information about French employees can be kept. The General Data Protection Regulation gives employees access to personnel information maintained about them by their employers, and it limits the circumstances in which such information can be disclosed. France has a limitation period of 5 years from the cause of action for initiation of legal proceedings related to employment disputes. If we have time, I can take a couple of your questions. Or if you have a question that you would like to have answered about retention practices in a specific country, you can contact me directly. And to the extent that I've covered that material in the AIEF study, I'll be happy to respond to you. Here's my email address, wsafety@safety.com.
All right, thank you very much, Bill. It was very interesting. So looks like we have one question from Chris Bednar. I'll post it on the screen here, but I can read it out also. So what are global firms doing when they have privacy rules that govern only half their employees? Do you apply the rules to everyone, or divvy up the employees by geography and apply different rules?
Well, that's a good question. I don't know the answer to it because it asks about the prevailing practices in organizations, but those would obviously be the two choices. The protection rules apply to a specific geographic jurisdiction, but outside the United States, there's pretty much common data protection rules. So, and those rules would appear to be prudent, even if somebody is just in the United States. I mean, this is a question that it goes beyond; it's above my pay grade. Somebody would have to make a policy about this in your organization. Sorry, I can't be more specific.
That's good. That's good. Another question is, does your study include payroll records?
I intentionally left payroll records out because they're covered by accounting laws and regulations. So the accounting study, which is available now from the AIEF, would cover that, Joe.
Okay, perfect. Next question is there a single repository to find out all of the non-global laws regulation by country regarding access, storage, transmittal, and or disposal of personnel records and or records overall?
No, that's the whole reason I did this report. Is there is no such study. That this is, as far as I am aware, the only single source that reviewed every country to identify applicable laws. So if you want that, it'll be out in, I don't know, a month or two from the AIEF. Then you can look up the individual countries you're interested in.
Okay, thank you. There was one more question. I'm not exactly sure what John meant here. He said, how would you classify the UN?
It doesn't have any laws of its own. It's not a country or a dependent territory. It's just it's an organization, not a political jurisdiction, not a political entity, certainly not a sovereign nation, not a dependent territory. It's like the EU. I mean, the EU would be classified as a supranational organization, but it passes regulations, and then some of its directives have to be absorbed into national legislation. But the UN doesn't pass any legislation of its own. It has no authority like that.
Got it. All right, next question. Would benefits records be included in personnel records and, for example, health insurance?
I intentionally omitted those because it would have made the study 3 times larger than what it is. They're covered by social services laws in some countries, but remember, some countries have nationalized benefits that the employers don't have to maintain individual information about individual employees' benefits because they're handled at the national level. So the answer to that, I guess, is no. I didn't treat them as a personnel record. Somebody may want to go back and do that type of study for social services laws, but only about maybe less than half of the countries would have relevant legislation for this.
Interesting. Are there any other questions? We still have maybe a minute or two.
I want to just repeat again this uniform retention rule concept. If you're looking for one rule that would apply to retention of personnel records across every country in the world where you might do business, then you'd have to keep everything permanently, since there are 7 countries that require permanent retention. But if you're looking for a non-permanent retention number, and with the fewest number of exceptions, all uniform rules have some exceptions, then that number is 10 years after termination of employment. The more you try to drive that down, the more exceptions you're going to need for specific countries.
That's really good to know. Thank you. I think we got one more question, Bill. So are records related to COVID-19 personnel records classified differently than medical records? For example, retention time.
If I'm not aware of that. If you have employee medical records that contain COVID-19 information, then they would be subject to the same rules as other employee medical records. In the United States, there's no difference unless it's an occupational health problem. There are no rules to specify how long employee medical records have to be kept that are kept by employers, but there are medical record laws that apply to healthcare providers. I don't know, maybe I'm answering this in a vague way. I would say generally the answer, I guess, is no, that there's no special exception for COVID-19 information. But if somebody did contract COVID-19 in the workplace, then occupational health and safety laws might apply. This is something that's been discussed and it's not been fully resolved. If somebody comes to work, somebody returns to the office, and of course, this is what employers fear. This relates to the discussion that we had, the presentation yesterday. Somebody returns to the office, somebody else comes in, they're infected, they infect others. Does that then become an occupational safety and health issue? Do they qualify for workers' compensation? Can they sue their employer for negligence? I mean, these are all issues that are pretty much up for grabs. As long as it's not in the office, it's not an issue.
All right. Another question. You mentioned the various industries. Was pharma included?
As far as I'm aware, pharma doesn't have any specific personnel record keeping requirements that or laws or regulations that differ from others, Karen. I don't think that's the case.
Excellent. Another question. Any information on records of offshore contractors? Obviously, they are not employees and the contracting company has the obligation, but is there any guidance about records the client's organizations may have?
If they're not your employees, then the laws don't apply to you. They do apply to the contractor. So there's no laws or regulations that would address your specific requirement as the agency that hires the contractors. It doesn't mean that you wouldn't have some operational need to keep these records, but you are not subject to the laws or regulations, that labor laws and regulations. The employer is.
Okay, I think we're about done and we're out of time, but I just wanted to thank you, Bill, one more time for the great presentations. And we've received a lot of feedback here. Everyone loved it. So thank you so much for your time and extensive research. I know I'm going to use it. I'm going to download this presentation. And by the way, all presentations will be made available to registered attendees for next 90 days. And we'll send you information on how to access them. And I wanted to thank GovQA one more time for sponsoring this session. It wouldn't be possible without them. And please don't forget to join us at noon for a cross-industry panel, which should be very interesting as well. Thank you so much.
Thanks to the sponsor again.
Thank you. Have a great day, everyone.